here. So again, welcome to Living Room. My name's Kristen. Today, and I want to say thank you to Gretchen for Samaritan Title for giving us our awesome lunch, which they do every month, and then introduce you to Steve, who is a tax expert. We're going to learn a lot about property taxes today, a lot of things that you didn't know, and information that you can use to empower your clients to be more informed buyers. So pretty great stuff. And I'm going to hand it over to Gretchen first. If you have any announcements for us.
I do just want to share one thing with you guys. We just came up with a new map application. So we get a lot of questions about the millage rate in certain areas. So we have a site called firstconnect.it, and under that are some map applications and external links. And this is a millage rate map. So you can literally go onto here and there's different colored areas. So you can zoom in and literally click on a parcel and it will tell you what the millage rate is, or you can enter the address up in the upper right or left-hand corner and it will show you where what that millage rate is for that property. And it will also highlight whatever right in that area, the other ones that have the same millage rate. So anyway, great little new resource that we have on there. So that's all I wanted to share. And then yeah, Steve does a great job. He has worked on the board at Clackamas County, but he is familiar with all three counties as far as the tax appeal process. So
Statewide.
Great. Statewide,
Yeah.
yes.
Right.
Statewide.
All right, we'll hand it over to Steve. We have a bunch of his cards too.
Thanks.
And make sure you sign in. There's a sign-in sheet going around. So
Yes.
make sure you sign in because you do get a credit hour, and I have your certificates. So before you leave today, make sure you get that from me because that's what you'll need to make sure you have your credit hour. So thanks, you guys.
I'm going to sit. Is that okay?
Totally.
Okay. All right. I want to be comfortable here. My name is Steve Anderson. I'm a real estate broker like you guys are. Have been for 28 years. In August 2007, I was approached by Clackamas County, asked to be on the Property Tax Appeals Board there as a hearings officer. I did it for 4 years. From my last case in March of 2011, was involved in over 2,000 decisions as a hearings officer involving values from a single-wide manufactured home in Malina, about $4,000, up to including Clackamas Town Center, about $165 million. So I've been involved in a lot of cases in that regard. Since then, I've offered my expertise to taxpayers in Oregon and Washington. We've worked with over 1,000 clients in 14 counties in Oregon and about 300 clients, 6 counties in Washington since that I moved over about 5.5 years ago. And I teach a class that's 9 minutes long. It's a basic class on property taxation, how the assessor arrives at value, etc. This class today is the last 3 subject matters of that big class because it's become a lot more prominent lately. We're going to talk about admitted property, exception value, and gross error statute. Who's heard me before? Anybody? 1, 2, 3, 4. Okay, so I got some virgin ears here. Okay, so I'm going to tell you a couple things. One is I talk fast. I apologize. And secondly, if you have a question, go ahead and ask. We're going to work off the handouts today. And essentially, I'm going to talk about admitted property first. It's the biggest one. It's creating more and more problems for us as realtors. Before I go into admitted property, there's 4 things you need to know about it. One is that the assessor, by statute, has the right at any time to assign any value to any property in Oregon. And you, the taxpayer, have to prove them wrong. It's the only concept in our country I know of where you're guilty to prove yourself innocent. Secondly, they all belong to RMLS. So when you put in descriptions and depictions of properties, there are eyeballs looking at that information that might not be beneficial to your clients financially. Be careful what you put into RMLS. I want you to market the properties, don't get me wrong, but I want you also to be considerate of what's in there. Third, before 1960, I defy you to find a building permit here locally. You won't. You might find a water permit for like a water line or a sewer line, but you won't find structures. They don't exist. They did at one time maybe, but they got burned out or whatever. In 1959, if I wanted to come along and redevelop this building here in Portland, I would go down to the city planning bureau, permit bureau. I could have a cocktail napkin with a footprint of this property and say, I want to do this in there. They would attach it to what they call a permit card. I write a check for the permit. Once the property was final, they would go ahead and throw the permit card away, typically, and the drawing away, and cash a check. That's still, up until 60, that was true here locally. Actually, some outlying counties even later than that. Before 1971, below grade square footage, basements, i.e. daylight ranches or tri-levels or split entries, were considered to be storage space, not living space. Because in the late 60s, builders were notorious for building homes with unfinished basements in them, so the buyer can move in and stretch their dollar, sweat equity they call it back then, and finish their basements out later. We come along as realtors 45 years later with 4-color photos of man caves, kitchens, bathrooms, bedrooms, etc., family rooms, whatever. And the assessor probably has never seen it before. So what happens is you have that information going out there on the internet, and the assessor's grabbing hold of that and creating these kinds of issues. So what admitted property is essentially is the real market value signed by the assessor every year is done annually, obviously. And if you list the property, to not be a sale, by the way, you can just ask for a value. If that listed value is significantly different than the real market value, let's say I got a $400,000 real market value, I've listed the property at $599. That piques their interest and can trigger or create this event. Okay, they'll look for pictures like you have on the RMLS of things they didn't know about, updated kitchens, updated bathrooms, square footage they weren't aware of, etc. Things happen in those properties without permits. You know, going back a ways, especially in this neighborhood here, you got 100-year homes. They're not, you know, you might not have permits pulled in 30 or 40 or 50 when something was done or added to the property, and you're adding it now as far as a picture of it in an RMLS when you list the property, and the assessor goes, we didn't know about the 800 square feet addition upstairs. We want to talk about that. That's what this triggers. Limited property basically is that difference between what they have it on the record as and what the asking price of the property is. And they can tax you for the current year plus the prior 5 if you're the seller and you lived it for 6 years. If you're the buyer, the way the statute reads, you're only liable for years you pay taxes on a property in. So if you buy the property, you can be hit with it for that current year. And I will tell you this, in 2015, I saw 7 different sale fails because of this one issue. Because what was happening was sellers are getting hit with this taxable event, if you will, and then the lender finds out about it on the buyer's side, and the buyer goes to requalify, and they can't meet the ratios because you jack the taxes at $400, $500, $600 a month. They can't make the payment anymore. So now your buyer's dissatisfied. They want their earnest money back. That's pretty much a simple, situation there. But they also want their sewer scope back, their radon test back, their home inspection back. Maybe they hired somebody to go out and look at the property and give them estimates on a roof or a fence or whatever. They want to talk about that. Oh, and they got the issue where they told Johnny and Mary, their little kids, are going to go to school in the fall at this little grade school over here. Now they got that pain and suffering they want to talk about too. And they're looking for someone to go after, and quite frankly, even though you never knew about this till today's class, you are the licensed professionals. It's your responsibility and duty to convey the information to them if you can. When you go into a legal situation, they sue everybody in sight, and what happens typically is the judges get down to the point where, okay, the seller didn't know about it, had no reason to know about it, they probably can get out of some of this issue, if you will, and they go after us because we have in most of our situations there. So that's what happens. And it creates a big problem for you because if you're hoping to develop a client relationship, it's not good to start with a lawsuit between the two of you. All right. So what is AR? If you follow me along here on the format, AR is what they use that as a blanket. It's a miscellaneous category. Judges hate it, by the way, and they don't usually allow it in court. But AR is assumed remodeling. So I got a $400,000 real market value and a $600,000 asking price. What the county might say is that we're assuming that $200,000 gap is because remodeling took place. We can't see or prove yet. We want to go out and look at the property to verify that information. That's how the basis for some of this information starts getting going here. So the way to deal with this is if you can talk to the county, you got a 20-day window when they send a letter out to discuss it with them. Yes?
I'm sorry, can you speak up a little bit? I don't know, 100 times.
I'm sorry. Okay. I will talk louder. How's that? Can you hear me now?
We didn't get what AR.
Assume remodeling. Yes, assume remodeling. I'm sorry. Most counties locally, how can I say this? Some do, some don't. They'll talk to me typically because they know I'll file a lawsuit against them. They don't want to do that. But if you call up as a homeowner, typically they won't discuss it with you too much depth. They'll tell you to go file a case at magistrate court, which is your remedy here to go, if you have a problem with the whole situation, you think you got a basis for an appeal, you can take it to magistrate court. There's a filing fee involved of $252 to the property owner. So that's one thing to consider. I just worked out a case today with Clackamas County on one of these, just this morning, as a matter of fact, I came over here. A lot of times we look at them, we can't do anything for the client. We look at them and go, you know what? They're right. I'm sorry, we can't do anything here. And that's what we do for clients and for you guys as a referral base, if you will. We'll look at that situation and try to tell you if you got a basis for an appeal or not. If you go to page 3 of the handout, This is what a notice actually looks like. This is from Clackamas County. This was sent to a property over in West Lynn. This property is on the Tualatin River. It's 1.9 acres. And what happened here was in 1942, the owner at the time built a 600 square foot cabin down by the river. I always want to play the banjo when I say that. In 1990, the owner at that time built a 4,000 square foot house up by the street where the utilities were at, the sewer, the water, etc. Darren Amico from Windermere put the property in the market, and he included, back then 16 4-color photos, pictures and descriptions of the 600 square foot ADU, his description, not mine, down by the river, okay? Well, the assessors didn't know about the cabin because it was built before 1960. So this bill reflects 6 years of value based on that cabin being added to the property. About $100,000 when it ends up being, or $6,000 in taxes, as you see here by the bill. If you turn to page 5, you will see where they made the adjustment on the tax bill. Went from $475 real market value to $630 because of the cabin, and it went from $355 to $368. I'm sorry, to $465 assessed value because of the cabin again. All right, taxes went from $5,800 to $7,440. There's a $1,600 jump, okay, or a $6,000 bill for the 6 years. Now, Mr. Matchek, the owner of the property, was unhappy, and Darren told him to call me, and he did. And I go through a whole series of questions with a client like this in this situation. The last one I asked him was, well, you've got on the market right now, have you considered an offer? As a matter of fact, last night we accepted an offer for $645,000. Well, class, what's the real market value right on this property right now?
630.
The 645 higher than 630? So the offer actually makes the assessor's case. We're done. I told him, write a check. We can't do anything about it. I have no basis to fight this thing with, okay? That's not always true. I have other situations where it's not always true. I have a lot of assumptions made by the county when they look at some of these properties, and they assume value. And I will tell you that their value and real market value in construction especially typically is way off, 30-40% easily. And it's not just Multnomah County, it's all over the state of Oregon. I got that problem right now. I've had so many construction cases in the last 12 months, it's not even funny. And I didn't have that many before, so they've gotten some real weird, wacky numbers. Yes?
I have a question about that particular cabin. If it was there before 1960 and it burns down, it's not rebuildable, why should they be taxed on it?
Because it's an asset, it's actually got value.
If it burns down, they won't let them rebuild it.
No, if it's burned down, then it's gone off the, take it off the rolls.
They will take it off
Yeah,
the roll?
yeah, take off the rolls.
Because when I challenged one of these, that was the case that they made, that this existed before, but it was not permitted, but it was not illegal. But if it burns down, it cannot be rebuilt, so it was not fully assessed.
Well, if it burns down, you can remove that value from the rolls. That's all you can do. You can deduct, you can't add because of that. All right, so some things to do and not do, do's and don'ts. Turn to page 6. This is a property on Skyland Circle out in Lake Oswego. You guys all see it? Asking price is $1.15 million, okay? Turn to page 7. What's the real market value in the property?
609.
No, 739. Is $410,000 a significant difference between the real market value and the asking price? I would say it is, okay? All right, and this one actually became a case. But what I want you to note, though, is the last comments on both the private and public remarks in this particular listing. What's it say? Okay. Clackamas County, Multnomah County, Washington County have assessor staff people that all they do is review overnight additions to RMLS. That's all they do. They're called sales data analysts, right? This is like waving a red flag in front of a bull, right? I understand it's a fact. It's lower taxes than the neighbor next door, but you're asking for trouble. In this case, they got trouble. They got lots of trouble in this case. It actually sold for $1,080,000, and Clackamas County, bless their hearts, they filed so many of these cases that they don't put a dollar value on them. It's a lien of record, potential lien of record, and they put a $0 amount, what the instructions call us. Well, in this case, I got a phone call from the listing broker on April 24th of last year. She goes, Steve, I need some help. We can't close this. We're supposed to close May 3rd. The county won't give us a pay-up on this lien. So I called the county assessor's office. I'm very familiar with them, by the way, and they're very happy to talk to me all the time. Anyway, I talked to them, and essentially they had not put a value in the property because they had not seen the property yet. And so I said, well, it's interesting because you filed a lien November 10th of last year, 5.5 months ago. So when did you ask for access? Last week. Okay, well, why would you wait 5 months? We're real busy down here. Okay, right, you sure are. So anyway, the next day they went and looked at the property, they came to the value decision of $1,080,000. It did trigger an event, and there was a check written by the seller in this situation. And they had to write it. We had no basis for challenging it. What based upon was a 1990 remodel of a kitchen in the house that was not permitted. So yeah, that was one of the reasons that they looked at, and that's what they took care of. So,
What was the cost of that check?
like 15 grand. Yeah, I've seen them bigger than that, believe me.
I have a question.
Sure.
So if they've gone to look at the house and the discrepancy in sales price was not due to any omitted property, just value increasing, it just happened to be that way, would there have been a liability?
There can be, they can still file the case, however, it's not gonna hold up in court.
Okay.
And the problem I have is that I get involved about 3% of these cases. There's like 95% of the cases they file that people just write a check. They don't think they can fight it. They don't think they can fight City Hall, so to speak.
Got it.
Okay, page 8. It's a tax printout of a property in Sandy, Oregon. And by the way, guys, I don't look for these in RMLS. If I did, I could find a bunch of them myself. These are cases that are handed to me. But on this page 8, can the class tell me how many bedrooms and baths are in this house? 2 and 1. How many square feet? 1417. Thank you. Page 9, same property. How many bedrooms and baths in this house? Excuse me? 3 bedrooms, 2.5 baths. How many square feet? Well, they got fertilizer and water. What they do to this house? Okay. All right. Oh, and by the way, while we're at it, let's look at the last line of the private remarks in this particular listing. This is on the internet, guys. Remember that, okay? What's it say? Okay. This is a real interesting story. This is a double one. I call this a BOGO, buy one, get one free. This one is a tax and a permit issue. Okay, yes.
That's private remarks, and why is the county allowed to have access to the RMLS that's owned by the realtors?
You're asking the wrong person. don't control RMLS board, but they have full access. Everything that's in there they can see, you can see. Vice versa. That's a question for the RMLS board. I didn't make that decision or sign off on it. They've had that authority for about 8 years, just to let you know.
Wow.
Yeah. That's what I'm telling you. Be careful what you put in there. This case is interesting because the owner of the property is a real estate broker. Now, wait a minute. She knew that her E&O wouldn't cover her in her own personal sale of her residence. So she got her friend in town to list the property for her. Do you see what happened here? His E&O is getting nailed. This is the situation, all right? We've got a big problem here. We got all kinds of issues in this. This is on a septic system. The septic system is designed for a 1-bath home. You now have 2.5 baths. Guess what? It's no longer legal. It doesn't fit the needed criteria. It's always backing up. Got issues there, okay? So if you go out on a listing appointment and you pull, I hope you do this, pull the information from the county before you go out there. And if you look at 2 and 1, you walk through a 3 and 2.5, and you look at 1,417 square feet, you walk through 2,400 square feet, talk to your broker. You might want to take that listing. You might have a problem with it, okay? Because it's going to fall back on you eventually. All right, so this is something you don't do. You don't advertise. Because this one here, essentially, we have Clackamas County now is involved in two different facets on the tax side and on the building side. And I will tell you this, when I get involved in these cases, a lot of them I have that the building side non-permitted. The tax is inconsequential. It's like $10,000. The building side can be hundreds of thousands of dollars to make this right. This house was built in 1930. They come back and make them ADA it, earthquake it, you name it. There's all kinds of lead and asbestos in this house, and they can take all that out. Abatement can all happen there. I mean, it can be, I've had situations where we actually tore the house down because of this situation. So, or tore the addition down that was not permitted. So, yes.
So this, I see this, line somewhat often, buyer to verify all home info.
Right.
So are they trying to not take responsibility for everything in the listing? Or what, I don't understand what that
Well,
allows.
I think a lot of people do that just to make sure that is a catch-all. I'm not a lawyer. I'm not a lawyer.
Yeah.
Okay, I'm not practicing law here. I think it's the realtor's way of saying, okay, well, you didn't see that, or you didn't do your due diligence here. Okay, but this situation, I mean, they've advertised back then in permits, so it's everybody.
Right.
It's sort of nonsensical, but if you went and sat in front of the judge or the board, that would mean nothing.
I'm sorry?
I said that would mean nothing if you sat before the board or a judge. Buyer to verify.
Right,
That
right.
doesn't release you of your liability.
No, it does not at all.
Right.
I agree with
So
her.
it's,
Is what it is.
Right.
They think they're being smart
right,
themselves.
exactly, but it
It
doesn't
doesn't.
really.
Well, no, it's an attempt. It's just not the full attempt. It should be, okay? All right. So, emitter property, the reason why I talk about this, up until about, almost 2 years ago now, I was seeing about one of these cases a month. I'm literally seeing like one a day right now. And I don't know if it's because I'm more popular, I've been out doing this for 5 years, or what, but I'm seeing a lot of these cases statewide. It's not just our local area here. Statewide, I'm seeing cases like this on and on and on. And I'm just amazed at some of the things that I come into running into. Washington County, some cases, some stories. Washington County, I had an attorney call me who bought a home in West Slope, which is a Portland address, Washington County assessment, in 2002. That's 14 years ago, folks. He bought the home. It was a 1955 day ranch. He bought in 2002. In 2013, 3 years ago, he got an emitter property notice from Washington County because in the 2002 RMLS printout it said updated kitchen. They hit him for $3,820 in taxes. He called me and wanted to know what he could do about it. And I said, well, here's the situation. You didn't build a kitchen, right? He goes, no, it was before I ever got here. I go, well, there might be some of the things in the house they don't know about also, and they're going to, part of this process, they want to go through the property and look at it. You're liable for everything in that house ever since it was built. So in 1955, it was a 3-tab roof, and it's now a standing seam, a steel roof or a tile roof. You're responsible for that difference in value. Not the guy who put it on, it's you, the current owner, the way the statute reads, okay? Secondly, the cost process involved in all this, okay? The filing fee, getting someone like me involved. I had to hire an appraiser for 6 years in that kitchen. It's gonna eat up $300 just like that. I mean, that's probably a break even at best for you. So I told him, I said, write the check, I'm sorry. Best news I can give you is write a check. Well, I don't like the idea of paying $600 more a year in taxes going forward. I understand that, but I don't see how you're gonna beat it. And oh, by the way, if they go to court, in that court, they can actually add the value to it. They can actually increase the value of what they got out right now. So be wary of what they can do to you, because you file the case and they might come back and say, you're right, we were wrong, it's even higher than we thought it was. So, all right? Yes?
But can you explain, so you said the buyer for the omitted taxes, when it transfers from sellers are responsible 5 years prior for
Right.
omitted taxes.
While they own it.
Right.
While they own it.
Right.
New buyers goes back a year.
No, it goes to the current
Goes
tax
to the
year.
current
Yeah,
Tax year.
yeah.
But then
It can
this
be-
person, it goes back further than?
Well, he was in the house for 12 years, 13 years, 11 years that time. And they can go back 6 years, current plus 5 years, when they find out about it, okay? I just had a case the other day in Charbonneau, same thing. She bought the house in 13. And they hit her for $45,000 on the kitchen remodel. 1972 built home, kitchen remodel like 1997. So I asked her, I said, is that kitchen remodel worth $45,000? She goes, worth a lot more than that. I go, then write the check.
Right.
We're done, okay?
But it was still 5 years
Yeah.
plus the current tax.
If you are working with a flipper buyer, when you buy a house for $200,000 in April and sell $400,000 in August, using about permits, by the way, you have a problem, right? The other problem we have is that buyers a lot of times don't know that there's been this tax event take place. And they don't find out until the following October's bill comes out. Happens a lot. Where the sellers paid the bill, didn't tell anybody about it, and then October the buyer gets the bill. I had a case in West Lynn where they bought a home out there. They closed the 3 weeks of September. The tax was prorated in $4,449. 4 weeks later, in October, the new buyer got the bill, the tax bill, $9,100 in taxes, because the seller paid an $18,000 emitted property notice in the May of that previous year. Didn't even tell his broker, didn't tell anybody. Okay, put it on the market, got the letter from the county, wrote a check, yeah, I did that remodeling I didn't tell him about, and didn't tell anybody about it. Well, the buyer went after everybody. Sued the broker, sued the owner, sued two brokers, sued the owner. And what is interesting in that case is that they don't want to talk about this, but the statute says that the assessor office has to notify the buyer, if they know the buyer bought the property, to notify them the fact to potentially have a tax increase here. And what Clackamas County said was, well, we didn't do that because we didn't know the buyer. Well, wait a minute, raise my hand. You recorded the contract. You didn't do it, the assessor didn't, but the clerk did in the county. So guess what? Clackamas County wrote them a check for the $4,200 difference. But that's just a one-year wonder, though. They can't do after that. So they're stuck from that tax base going forward. So little cases we get involved in. Yes?
Just to be clear, own a house for 4 years, and house is sold, and a year after it's sold, it gets reassessed, and the assessment finds triggers an increase, at that point is the previous owner?
No, once the property transacts, it's the day the letter goes out. Whoever's ownership that day is the one that gets the letter.
So new owner would be responsible for all back
No,
taxes?
no, just from when they bought it.
So nobody's responsible?
But I want to qualify that. It's not uncommon for the county to send out a 6-year letter anyway. Even though you bought the house 10 months ago, send you 6 years of taxes. I get those a lot. No, you only own for the 1 year. Or what I get a lot of comment, by the way, is people who own the house for 30 years. And like right now, this time of the year, I want to sell my house in 17. They talk to their broker. They put 100 grand into the house and put it on the market in March. It sells in April for 100 grand more than what it should have sold based on what the values were. And the county sends a 6-year letter out and say, wait a minute, we didn't know about this. Well, the actual event took place 4 months prior. It wasn't 6 years prior. And I can prove that through receipts. We do a lot of that, quite frankly.
So
And
you
so-
have to know.
Yeah.
So if any of our clients get a bill for several thousands of dollars of 5 years back, then we tell them to call you.
Yeah.
They may need to look into that further, that they're only liable for the current year, right?
It,
Or
it,
from
it,
when they bought
it's
house.
from, it's from when,
When they bought
the statute says from the person who paid taxes on a property is responsible for the year they pay taxes in. So you bought it this year, you're only responsible for 1 year. But it's not uncommon for them to send you a 6-year bill, because once again, they know most people don't know this law, they write a check for it, so what? And it's just a clerical mistake on our part. That's what the county would say. No, it's not, it's intentional. I'm sorry, yeah. I know. We had a new clerk that day. Okay, yes, sure,
So, you know, we have all these houses that are being flipped, that were derelict houses.
right,
And when they were assessed, they were livable houses.
right.
And so you're restoring this to a livable condition. Why do they have a right to say that you don't get to restore it to a livable condition, which is what they originally taxed it on?
They're not saying that. What they're saying is that what was the value of the property when it transacted? That's what they're saying. And so, and the issue I have there is that a lot of times the sales price is what they use for their basis.
Right.
And that might not be the truth in all cases. It can be in most cases, but not all cases.
And to paint walls and do a lot of the things that you have to do, there can be little or no expenditure.
Well, that's the next part of this class, okay? You're segueing here on me, okay?
I'm psychic.
All right, yeah. I'm sciatic, so we're close, right? Right? Anything else on this? Simpatico, there we go. Okay. A couple things I want to finish up on this one topic. I talk and deal with assessor staff people every day, statewide. Through emails, phone calls, literally I'm on the phone pretty much every day with somebody in the state of Oregon talking to them. They're not bad people. They really aren't. In fact, a lot of people that I talk to, I don't know if we're having bromances, but we're friendly with each other, okay? Now, the supervisors don't care for me because I'm taking money from the county, which I'll get to that later. But they have told me more than one person's told me this, is that the way the laws are in the state of Oregon, you know, Measure 5 was brought about in 1990. Don McIntyre led that one. He died 3 years ago. Measure 50 was done by Bill Sizemore. He's selling carpeting over in Idaho, okay? There's no one here to guard the hen house of the Oregon taxpayer on property taxes. So consequently, they're getting more and more aggressive. And what they did was they introduced a bill last year called House Bill 2080, which didn't go through, thank God, but I see it come back in 17. It's right here in your handout. House Bill 2080 would, get this, reset the assessed value. Now, real market value and assessed value on your tax statement, the AV is usually lower than an RMV. You guys with me? Would reset the assessed value in the following year to the sales price of the previous year. Are you with me? That's a tax increase on every property that transacts. Every single one, okay? Oregon is the only state in the country does not have a reset on sale clause. Washington does, California does, Oregon does not. If they want to have that, let us vote on it. This is a way around that. And they didn't get it passed, thank God. They also, in 17, are telling me they're going to pass or put a bill up there, I hope they get passed in legislature, that will allow them to emit a property on any event on the property. For instance, where's our mortgage person at? If you refi the house and the mortgage amount is higher than real market value, bingo, 6-year letter, okay? Because when you refi, you have to put the mortgage amount on the deed. So we have to be careful here because it really would impact our business negatively, in my opinion. I don't want sellers and buyers being, scared of property taxes on transactions. That can happen here. I did a spreadsheet for you on page 11 with the submitted property. I showed you the property in Skyland Circle in Lake Oswego. We started at $8,522 in taxes. You guys with me on that? Okay. I projected the admitted property being $12,897 because the bill hadn't come out yet. It actually was $13,039 was the actual new bill. Under House Bill 2080, that same property would have been at $15,260. You see the $7,000 spread between the current taxes and the new taxes if the 28 had gone through? That's almost doubling of taxes. We're going to have problems qualifying buyers. We're going to scare sellers because they won't be able to relocate in Oregon based on this tax base, if you will. So this can happen. This is they're trying to happen. Well, they already are going up. You know that. More.
Elderly.
Yeah, it really is. Really affects the elderly.
They can't come up with a.
So yes,
Slightly confused. Is this House bill proposing that the most current sale for that property is the new real market value?
new assessed value, not the real market value. Real market value would be actually higher than that possibly.
Okay. And then, all right, so if the house got sold 10 years ago,
Right.
X amount of money, then pretty much every single property can get a new assessed value. So you're saying.
But this is based on a sale in the prior year, so it'll only be affected by properties that transacted in a 12-month
Within
period.
the last year.
12 months, yeah.
Oh, within the last 12 months.
Right, right.
So
But it
if
would
you fall
be
outside
every
of
year.
that, then you don't have a new assessed value.
Potentially no.
So if you sold in 2010,
Wouldn't
you're-
this
it's not gonna change.
the way it's written, the way it was written, it would not affect that. No, to answer that question. Okay, exception value. You brought that up. I'm going to finish it up for you. Okay. Exception value is the second part of the class. What exception value is? The assessor is required on the 1st of January every year to assign a value to a property. Every property in the state of Oregon has a value assigned 1 January at 12:01 a.m. As a matter of fact, that's what statute says. So, for instance, if I'm remodeling a project, a home, let's say, and I've got a $200,000 remodel going on, I start in October and finish it in March of the following year. Let's say I'm exactly halfway through the remodel on the 1st of January. The assessor would take the $100,000, add it to real market value, and a portion of it would go to the assessed value. The other $100,000 would be floating around to the following tax year. That's called exception value. It's sitting out there, it's going to be attached to the following year, okay, as taxes, right? Let me tell you the problem with this is that, especially in residential, I think commercial too, as a matter of fact. And it's not the property owners I'm seeing the problem with, I'm seeing it's the contractors. When you get a final permit on remodeling or new construction, you're required to put down a dollar amount of the project. The dollar amount is the improved value of the project. It's not the total dollar of the project. And I see most of these contractors they'll put in the porta potties, the drop boxes, and all this other stuff. You don't pay taxes on non-improvements. For instance, in this neighborhood, I got a lot of properties, Alameda, this area here, about this age home. The older the home, typically this is more and more prominent. When you're replacing existing sidewalks, or existing driveways, or sewer lines, or water lines, if I'm painting inside and out, re-roofing, if I'm replacing existing deck, like for like product and size, or existing fence, same thing. Furnaces, if I'm doing dry rot repair, if I'm taking EFIS off and putting hardy plank siding on a house, those are all maintenance. You don't pay taxes on maintenance. And yet I see it happen every single day. I have probably 3 dozen of these cases on my desk right now. They're a hair puller for me because they're just so many different pieces moving here. And what I see typically is the contractor has gone ahead and taken the total dollar amount of the project, put it on the final, and the assessor says, thank you very much, add it to real market value, portion goes to the assessed value, and I got a property owner call me the following year saying my tax went up $4,000 on this remodel, what happened here? And I'm looking at it going, a lot of that was not taxable. It's a very expensive process to tear it apart, fix it like it should be, and typically when I talk to the assessors, they laugh about it. Oh yeah, we should have caught that. They know it, they don't do that. Let me give you some examples. Alameda, you guys know that area. Very nice view properties up there. I had a case last year where a gentleman had a retaining wall, because he had a very slope property, deteriorated. For 91 years they do that. He hired an engineer to come in with a crane and dismantle the old wall and replace it with a new wall. $103,806 wall he put back in, okay? Which the assessor took and said, oh, that's improvement, thank you very much. That's exception value. Not one dime of that project is improvement, it's maintenance, okay? Washington County, you guys are all Oregon realtors. You know, you have good appreciation for this one. A guy hired a contractor who came with a backhoe in his backyard. He dug a nice big square hole in the backyard, shot it full of gunite, put stuff around it. $88,000 later, he had an in-ground pool. And Washington County said that's a real market value, $88,000 adjustment. Folks, what is an in-ground pool worth in Oregon?
Negative.
It ain't worth 88,000. I think I've seen $15,000 most ever in appraisal for in-ground pool. A lot of times you're right, it's negative. It's negative, okay? And they threw it all on it because they had a final permit signed by the contractor for $88,000. They said, where's our proof right here? The property owner told us $88,000 improvement. No, it wasn't. It's the market value of that improvement. It's not the, you know. So that's what we deal with a lot in that situation.
So, just to be clear, if your buyer or your seller gets a bill for that and the tax is being assessed and it's gonna go higher because of that, what kind of process do you have to go for you to appeal?
Well, you appeal the county first. Typically, they tell you to go file a case at magistrate, and then you come back. When you file a case at magistrate, they'll usually talk to you. We file a lot of cases.
Does it cost money is what I'm saying? Like,
$252 to
will it cost a lot
file.
of money to appeal that?
$252 to file with the magistrate court, state of Oregon. And we filed 100 cases a year in magistrate court. I have not been to court since March of 14. All those cases get worked out. They all get adjudicated out. They have stipulated out, they call them. Why? Because if we prevail in court, which we will, the county has to pay our costs. And a lot of times those costs will exceed the refund. And the assessors have the ability to write refund checks all day. I don't know any of them that have the ability to write checks to me for representing you on your property. They have to go to the county and ask for permission. They don't want to do that. I know that. They know I know that. That's the game we play. So, yes.
So, I have a property that is right off I-5, it looks at the I-5 wall in North Portland, and it was a quarter house, it's horrible before it was flipped. Property taxes are like $600 a year. All the improvements to the house were just making it livable again, it's still the original kitchen, it's just cleaned up, but they didn't pull permits for everything, so
Mhm.
for the furnace, and so I told my client, sorry to close, your property taxes are probably gonna go up a lot.
Mm-hmm.
Will she be able to, and will she be able to argue some of that? I know her.
Send me the bill in October. I'll look at it for free. I'll tell you if she has a basis for appeal or not, and I'll do that for you.
Yeah, I'm really curious about this. I'm trying to understand the difference between what you're saying, like maintenance versus the market value.
Mhm.
Like, say they replace the siding and put new hardwood on, right? Like, that's maintenance, but it also increases market value, so is that taxable?
It's amazing. I agree with you to a certain extent, but if I go to court on that, siding is siding is siding is siding, typically. And it depends. If it's a real nice big home, you know, okay, maybe a small amount can be considered there. We even have problems with, and I've won cases in court with this, where you have a 1962 day ranch, let's say, with single pane aluminum windows, because that was the big thing back then, okay? And someone decides, I'm tired of having these things sweat in my wood casings, I'm tired of having the air come around the whole thing, I want to put something in, I want to put in vinyl windows, okay? What the assessors will say is that's an improvement. We've gone to court and the judges said, no, it's not, because single pane aluminum windows are not available anymore. You can't buy them. It's illegal to make them, it's illegal to sell them, okay? So the lowest cost product that's comparable to the old single pane window is the vinyl window, and the courts say, you know what? That's a reasonable, now if I put on Pella or Anderson windows, it's a whole different story. But if I was to go to Home Depot or some economic place and buy vinyl windows and put them in those holes, the courts have upheld that. The assessor won't tell you that. They'll tell, well, no, it's an improvement. They're always looking for revenue. That's their, and they're doing a good job of it, by the way. Okay.
And is this process the same for septic and commercial as well?
Yes. Yeah. Yeah. Okay. All right. So, you all exception value. You all know all about that, right? No problems. I can ask questions now about it, right? Last thing, the good news. It's called the gross error statute. The gross error statute, 305-288, says that if the assessor assigns a real market value to a property, residential only, by the way, and residential is 4 units or less, as 20% or more above the actual market value of the property, you have the right to appeal for that year plus the prior 2. Now remember now, when they catch you, it's 6 years. When you catch them, it's 3. Okay? That's how fair the system is. And you have to, this one you have to file a magistrate case. They won't even talk to you until you file a magistrate case. So it's $252 to file. We have filed well over 100 of these cases, and in fact about 150 of these cases in the last couple of years. Like I told you earlier, I haven't been in court since March of 14. I like to go to court too. I really do. I do well when I go there. You know, and the thing about it is, when we prepare these cases, when someone hires me, within 30 days of us signing that letter of engagement, I have my full case ready to go. Because I can't take a chance that I won't have enough evidence put together. And they know that. The judges know that, and so the county. So we do a real good job preparing for the case. We also turn down more cases than we take because we want to have good evidence, and a lot of times we can't get that. But I want to show you some examples of what happens. Turn to page 12. This is the house on the lake in Lake Oswego. I was after Teresa for over a year to do this in her case. She had on the market for $2.5 million when she finally capitulated and decided to go ahead and hire me or engage me to do this for her. She had spent $4.5 million building a home that was a shell on the lake in Lake Oswego. And she pulled the plug on the project in 2009. A good idea, by the way, because 2009 was not a good time to be building in Oregon. The house was, they call it the turret house. It was an English-style castle. When I walked into it, there was insulation, but no sheetrock. The front door, honest to God, was a 4x8 piece of plywood with an electrical wire for a handle. The lowest level was an in-ground saltwater pool with $400,000 of equipment to support it, not a drop of water in it. There was on the lake, there was a boathouse with an electronic boat lift. No boat in it, no one living there, obviously. So she spent the money there, but it wasn't the market value of the property. They were trying to sell it for $2.5 million. And so I got a hold of Clackamas County after we filed this case, and we settled at $50,797.56. So she was a pretty happy camper on that one. Got almost a year's taxes for her, by the way, back on that situation. Page 13, Bill McCormick. This is an interesting story. Bill lives on the confluence of the Tualatin and the Willamette Rivers in West Lynn. Bill bought the house in 2006 from a guy named Jerome Kersey. You might recognize that name, okay? Jerome built the house in 97 on 20 acres. In 2000, Jerome sold 6 acres next door on the Willamette to a guy named Brian Grant. You might know that name also. Brian built a house next door. And the reason why I ran to Bill was Brian had his house on the market for 1,119 days. That's called market exposure. Finally sold it for $3.2 million to a guy named Steve Lemma in 2014. I wrote Steve a letter because his $3.2 million sale triggered interest because the county had his property valued at $4.95 million. So I wrote Steve a letter and said, you got a 1-year event here because you just bought the property. Talk to me. I think we can save you at least $10,000. He got a hold of me. He engaged me. We got him a check for $13,860, what it was. Well, Steve and Bill share the same driveway. So April of last year, I got a phone call from Bill McCormick. Calls up. You don't know me from Adam. I'm Steve Lemma's neighbor. We share the same driveway. Okay. I saw his check, quote unquote. I want some of that county cash. How do we do this? And I said, well, you're a three-year appeal because you've been there for over 3 years, and his property was about $3.4 million based on the sale of the property next door, and they had him valued at $5.65 million. So we went ahead and filed the case. They take between 6 months and a year to work through because I'm dealing with a county and a court. So stuff oozes, it doesn't move very fast. But while we're doing this, the one nice thing about this program, statutorily, you're getting 1% per month interest on the money from when it was paid, not when we filed the case, from when the overpayment was made. So in this case, well, in Teresa's case, about $11,000 that was interest. In Bill's, about $14,000 that was interest. But I tell my clients up front when I get involved in these cases, it's a long, drawn-out process. And usually most clients, like every other month, will send me an email, hey, give me an update on what's going on, whatever, because I do charge a retainer up front against this stuff. So there's some investment on their part when they get involved in these things. Well, Bill religiously called me every other Friday afternoon. Every 2 weeks, I got a call from Bill. Every other Friday afternoon. Hey, I gave you a retainer. Haven't heard from you in a couple weeks. Are you in Vegas, Miami, or Rio with my money? What's going on, And I just call back, Bill, tick, tick, tick. Money's, He goes, well, I'm going to look concerned here. It's been 6 months. Well, I'm sorry. I don't know how to prod a court or government to move faster than they are. So this check came into my old office in Gresham on a Friday morning. I think it was August 6th of last year. About a year ago, yeah. And I called Bill up. And I said, Bill, your check's here. Great. How much is it for? And I said, well, Bill, when I do these cases, I try to give him a ballpark of savings. What do I project for you, Bill? And he says, about $45,000. Okay, Bill, it's not for that amount. And before I get to anything else, I've been married 35 years. So I know when someone yells and someone listens, it's called a conversation. So we had a conversation about 2 minutes where I listened. We discussed my real estate license. We discussed his law firm, what they're going to do to me. We discussed my parentage on several different occasions. And he's going to hang up and call his attorney. I go, no, Bill, wait a minute, before you do that. And so, well, why should I do that? He's really mad. I go, the check amount is, I read it to him. Dead silence. Bill? I thought he passed out. Bill? How much is it? I says, well, 59,000, whatever it is. And he said, when can I have it? I'll mail it to you today. It's on its way. I tell you that story to tell you this one. Up on Skyline Boulevard, right above the zoo, there's a project called the Skyline Condos. Built in 1956, it's 2 buildings, 25 units. They were built apart as apartments. In 2006, a gentleman bought them and converted them to condos. They were brought back on the market in 2008. They were selling for around 3.5 when they were selling in 08. Of course, 09 came and they couldn't give them away. Since 09, the highest sales price on that project's been $149,500. I got a phone call from a home inspector, by the way, who heard about me through another realtor, and said, I need to talk to you about this. I think they're way out of whack. You can go out and talk to myself and maybe some of my neighbors. I went out and there's 12 of them. I met them in our little rec room there. The county had them valued between $221,000 and $283,000. Now, I just told you earlier that the highest sales price is $149,500. 9 of them hired me to do the same thing. They all got checks between $4,000 and $7,000. Now, obviously, I didn't make as much money on their case as I did on his case, but if you would have told me in 2014, I representing $140,000 condo owners in state court, I would have laughed you out of the room. So this works universally across all price ranges, all products, if you will. We had several cases in Hayden Island in 32 cases in that island alone. So much so that Multnomah County went and revalued the whole island. They lowered the value by 18% in an up market because they didn't want me taking them back to court again on the other properties that were there, okay? So, that being said, the last page, the assessor uses this license. There are less than 100 people in the 3 counties that are locally combined that make value decisions on over 500,000 properties locally every year. That should make you really feel good. Of the less than 100 I just mentioned, less than 10 have current fee licenses with the state of Oregon, appraisal licenses. They have these kind of licenses instead, issued by Department of Revenue. Why? If a fee licensed appraiser makes a mistake on a valuation, like they put too much value on it, which the assessor does a lot, by the way, you, the taxpayer, or the property owner that's affected by it, can take them to task and file a grievance or a complaint with the ALCB, the Appraisal Licensure and Certification Board, and they have teeth. Their smallest fine is $2,500. And the way the law reads is that if that person that made the wrong valuation on your property is working for somebody, i.e. the county assessor's office, the employer is responsible for the fine. So the assessors a long time ago, if you walk in the door with a fee license, give it back, we'll get you one of these instead. It's equivalent is what it is. As you can see, any idiot can get one of these licenses. There's a guy named Steve Anderson's got appraisal too. I got it in May of this year. I had a 1 last year, and I got socially promoted to a 2 this year because I was a 1 for a year. That's how government works, right? I'll be a 3 in 18, yeah, which is the highest you can go, by the way. I tell you this story because in order to keep this license, I have to go to ongoing CE hours. I have to have 60 hours every 2 years, which means I'm going to classes with assessors and their staff people. When I walk in the room, I'm 1 or 2 people in the state of Oregon has a license and work for a government entity, okay? When I walk in the room, I hear comments like, what the hell is he doing here? How do you get in here, okay? Kind of like when I go home at night, same thing, okay? Anyway, so I don't want to say this is a big issue, but my wife quadrupled my life insurance when I got it. I am starting a Go Help Me account for my Kevlar vest and my helmets when I go to these classes. No, it's funny because the guys that I deal with every day, they laugh at this. They go, you got one of those too? Everybody's got one of those. I go, well, that's what happened here. So I tell you that story because it is kind of fun. And we have been able in the last 5.5 years to collect over $2 million in refunds for our clients in 2 states, okay? That doesn't bother them as much as this does. And anything about me at all? The money's important, but just the fact that I'm doing this to the man is really a lot more fun, okay? So, that being said, how do we work? What we do for free is we look at your property taxes, your property tax statement for a single family dwelling or a single tenant commercial building for free. Don't send me Washington Square with 70 tenant attached leases. I won't do it for free, okay? And we try to determine if you have a basis for an appeal or not. If we do think there's a basis, we'll try to give you a ballpark where the savings are. We don't guarantee results, but we're very successful at what we do. We don't win every case. I wish we did, but we're pretty close to winning every case, quite frankly. The assessors know when we file the cases that we're going to probably prevail, so they try to work things out with us. The boards know that locally, and the judges know that in the state of Oregon. So that being said, we turn out a lot more cases than we take. A lot more cases than we take, because they don't make sense. How we do this, we upfront for free, we make the evaluation for you. Your client going in, your client's come back out again. You can ask any broker in the state of Oregon. I've never crossed that line. I have my own book of business, getting smaller all the time, by the way, because I'm doing more of this. But we do that for you for free. We're a resource for you for anything dealing with property taxes. We've done residential, obviously, commercial. I've done gravel pits, billboards, trailer parks, campsites. You name it, I've pretty much done it. I've been involved in it, okay? If we go to the local tax appeal board in, say, Multnomah County, and if the client hires us, we charge $350 up front. We become them. They sign a piece of paper. We do all the filing for them, gather all the evidence. We go down and testify on their behalf, and then we let them know what the outcome of the case is. We charge 20% of the savings for that 1 year if we prevail. For state court, we don't do as many cases down there as we do locally. We charge 30% against the total amount of refunds given, and we get $1,500 of that up front. It's a retainer against the 30%. So that's what we do. A couple things I want to tell you also. The other Living Room Realty has scheduled this with me. You guys can do this if you want. I do a 20-minute presentation. It's a lot. We don't even talk about this at all, by the way. We talk about compression, and we talk about how to read your tax statement, that kind of stuff, for the general public. And what happens is a lot of realtors, I have law firms, I have CPAs, I have mortgage brokers, I have financial planners that will do this. I'll be happy to come and do that for you. I just ask for 15 people to be here, minimum, taxpayers if you will. We call those wine and wines, okay? And by the way, I like red wine if you can do that. Anyway, we do those, and your office on 25th in Alberta, 26th in Alberta? 14th Alberta, okay. Has scheduled something in November with me already on that one. I'd be happy to do that for you guys here too. All I'd ask you is your clients come in with their tax statements. I'll look at them, try to figure out if they got a basis for appeal or not. And I think I can explain it to them better than you can as what they're looking at in that situation. I do a little 20-minute presentation, and then we talk one-on-one, going around the rooms what I do. So we are a resource for anything tax purpose-wise. We've done 3 HOAs involved in the historic preservation tax, the 10-year freeze. We've done those. So if you have a question about property taxes, we want to have you come to us. Don't go to the assessor's office. Get the right answer up front. With that being said, I think I'm done. Any questions at all? Yes.
So we often have floor plans drawn by professional appraisers for marketing, so that the buyers can see what the floor plan is of the property. Those floor plan square footages rarely match
You're right.
to what the county has.
Right.
So do you recommend we just stick with what the county shows?
No. No, what happens is this, is that the assessors have proven to the courts that they're not allowed into most of the properties, so they're allowed to tax you on the envelope, the outside walls.
Okay.
Appraisers give you living square footage,
Right.
the assessor will give you total square footage. So
Okay.
in my opinion, you're better off advertising what the appraiser gives you, not what the assessor gives you. That's my opinion
It's
now.
living square.
Well, it's real living square feet.
Right.
You can't live in a wall cavity.
Right.
With insulation's out, okay? And the difference is on a 2x4 construction, about 4%, 2x6 is 6%, between what the assessor says and what the. Now, that being said, I've had lots of cases in the last couple of years with brokers, by the way, real estate brokers, managing brokers, as a matter of fact, where they've had homes that were overassessed or overtaxed because the square footage was different than what they really had there. As a matter of fact, the last year I was on the board, we had the head magistrate of the state of Oregon came in, okay, I don't deal with her anymore, she retired, but she had an 800 square foot differential in her house in Tualatin. She didn't know she had a problem. For 12 years, she paid too much taxes on her house, and she's the head magistrate of the state of Oregon.
We've been having the opposite happen, where the appraiser says we have more square footage than what the tax records show.
Okay.
And so then we don't know which to go by because
If you advertise it, you're going to probably have a problem with the county. Now, it depends. It depends. And there's a little trigger here, okay? It costs the assessor, they don't ever tell you this, it costs us about $1,500 to make that what they call tax roll correction when there's a discrepancy on the tax roll, okay? So if it's 30 square feet, 100 square feet, they really can't cost effectively do that. If it's 400 square feet, they'll talk to you about it, okay? So, I hope that answers your question.
Okay.
That's your threshold.
Yeah.
You didn't hear it from me, by the way.
No,
Yes?
If there are updates to the house, what are you suggesting, to not red flag too much by talking to?
I don't have a problem with you saying updated. I just don't want to see dollar amounts in the year that's done.
Okay.
okay?
Okay.
All right, because your dollar amount might be different than what the real amount was.
Okay.
And by the way, while your broker's here, moment here, okay? Anything you put in the brag box on the internet, have your client initial sign off on, because I've been involved in cases where the homeowner said, I never told him to say that. Because the assessor's standing there with a bill going, you owe us $18,000 because what was in the printout here. And the homeowner's going, well, I never said that. And I know as a broker, we don't make those, I shouldn't say we don't. We typically don't make those things up. It's dollar amounts and years that work was done. Yes. You had a question?
How far back, if somebody just pays the bill because they don't know, or they just don't wanna fight it because it takes a lot of effort, how far back, if they change their mind? Like my clients that paid, that wrote a check that I talked about a while ago, if he decides in a year or two.
You got 90 days. 90 days is the event. He's done. He's done, 90 days. Well, I shouldn't say that. If I can prove that they were wrong, I can do the 3-year on them now, the 305-288. I can go do that now. If it was that wrong, it doesn't matter what he did a year ago, because I go back and change the value if it was wrong, but I got to be able to prove it's wrong by 20% or more.
What's
So
the 90-day thing? What are you talking
on a omitted property notice, once the decision is made, once they've imposed the value or increased the value, you have 90 days to appeal to the magistrate court.
Okay.
And then it's actually in the letter that I gave you here. I think it's in there. Should be in there. If not, that's what it is. 90 days. Yeah, I'll find it for you. Anyway, yes.
Might be a silly question, but, let's say a client, pulls permits, does a kitchen remodel, bathroom remodel, and then gets all the permits finalized, and then the tax assessor comes and knocks on their door.
Don't let them in.
Okay.
Yeah, that was.
Never let them in.
All my clients?
Never let them in.
Can I actually tell them?
Call them. Have them call me. I'll give them a spine.
Yeah.
All right.
Yeah.
Don't let them in, because they're there to find evidence and
that's
value to
that's
support.
what I tell people, but it's
Yeah.
not-
And they're going to make assumptions anyway. They will,
Yeah.
but they do it all the time.
Well, I've had them knock on clients' doors
They-
that didn't even do work.
Right.
And just new buyers.
Right.
you know.
Here, okay. Let me tell you what's going on there.
Yeah.
They've got a real market value assigned to the property, and that property probably transacted below their RMV they had assigned to the property. They're trying to find value there to support their dollar value, not what the sales price was. They're looking for something in there that's going to trigger an outlier, they call it, okay? Don't let them in the property. The statute says you have to let them on the property, doesn't have to let them in the property. So,
Same for this omitted, when they send, that sounds like you have to let them in if they send you an omitted.
well, if you file a magistrate case, which is the way to remedy that, the magistrate judge will require you to let them in that's
They
what.
don't do it before that.
Right, and that's one of the things I do when I ask the question to people, have you done something we don't know about, that they don't know about? Well, yeah, then we're done. Why expose yourself to even more taxes? Don't do that.
But letting them in, does that include the backyard?
Well, they're allowed in the yard anytime they want, by statute. The Oregon State Supreme Court made that decision years ago.
Through Gates Strong.
Yeah. Well, I had a case in Washington County 2 years ago. A gal bought a house in August, 2-story home. It was a daylight ranch, as a matter of fact. Was up on the upper deck sunbathing in September, and she heard a noise, looked around. There was a guy with a camera taking pictures through her window in her basement. And she screamed, was going to call 911. He goes, well, I'm from the assessor's office. She goes, you got to tell me who you are. I could have shot you. I said, you should have, by the way, but no, just they can do that kind of stuff.
Might cause a tan line if you're kidding.
Or those powder burns aren't nice on your bikini, right? Right. I have business cards here. If you have any questions, feel free to call me or email me. I do a lot of business with you guys. I get a lot of referrals from you guys. I appreciate that. Thank you very much. And if I can help you in any way, we can help you in any way, let us know. We are the largest filer of these kind of cases in the state of Oregon, have been for the last 3 years. And I'm not involved that much in the quantity, I'm in more in the quality. Like I said, we turn on more cases than we take. A lot of my competition doesn't do that. They'll take any case they can. So with that being said, I think I'm done. Thank you very much.
How's this kid? Let me see if notice. Thank you very much.
Thank you.